Welcome to Haunt Topic Radio, the podcast for haunters by haunters. These are our scary visions.
Welcome back to another episode of Haunt Topic Radio. Some think legal stuff is boring, but you gotta know it. In this episode, we talked to Matt Murphey. He's a lawyer by day and a haunt lawyer by night. So, he knows a lot of things about the law, and we talk a lot of things about the law. This was a live Hunter's Toolbox Masterclass, and if you want to join these masterclasses, make sure you go to hunterstoolbox.com and sign up to be a member. We have free plans and we have paid plans. Paid plans give you a starting point on getting your haunted attraction. We have a bunch of master classes on our website, how to design, how to build, how to start a business plan. We have all that on our website. If you become a free member, you get a few videos for free, get some free master classes. So just go over there and sign up. You get on our list and you'll know exactly when our next master class is coming. Our next master class is going to be with Bart Butler from Terror in the Corn in Colorado, June 10th, 7:30 p.m. Central Time. Go sign up at hunterstoolbox.com and you'll get an email when the class is scheduled. So in this episode, we talked to Matt about all kinds of legal stuff. If you're a home haunter, we talk about HOAs. If you're a haunt owner, we talk about waivers and paying your employees and copyright stuff, insurance, just a bunch of stuff. We were asking questions from the audience. They were giving us good questions. It's definitely worth an hour of your time to listen to this episode. It might save you thousands of dollars. Once again, we're shipping out scare badge orders. We do it all year long. We have some new badges that came out. We haven't released those yet, so stay tuned on our Scare Badges Facebook page. We'll start putting some stuff out there. If you are on Facebook, please join our Hunter's Toolbox Facebook group. Just go on Facebook, type in Hunter's Toolbox. It should pop up. It's a private group. Request permission, and I'll let you in. We do a lot of conversations over there too. So we just want you to be the best haunter that you can be. Well, let's roll into it. Our master class with Matt Murphey about all things legal and the law of haunting. Matt, tell us a little bit about yourself and what you do.
Okay. My name is Matt Murphey. I've been a lawyer since, 1998. Before that, I was in the military, in the Army. I am a lawyer. My wife is my boss. She is also a lawyer. And I'm coming to you live from beautiful Lake Arrowhead, California. I am a haunt owner and a haunter, and I've been that since 2017. If anybody ever sees Wraith House's Instagram or Facebook or comes across our website, I talk incessantly about my daughter Peyton, who goes by Tito Murphy. She's been with me from the very beginning, 2017. And although she's an adult now doing adulting things, she's out on her own, but she comes back to work the haunt every year. So in addition to that, I sit on the legal counsel board for the Haunted Attraction Association. Generally, most of the questions that come in from members are directed to me, and that ranges from anything from what can I do about somebody saying that an actor touched my kid, to we had a blowout of an electric circuit and some people ran out, some people fell, and now I'm getting a letter from a lawyer. What should I do? I am also part of 916 Productions, the boys down in Houston, Ryan, and the guy with the real long beard, Shane. And I'm with them every year at Trans World. So if you've been by the 916 booth, you might have seen me there. This white beard usually gives me away. Yeah, and that's me. I'm really interested in this topic tonight and looking forward to questions and answers.
And you have a little haunt that you do yourself, right?
Yes, our haunt is known as Wraith House. It is in Lake Arrowhead now. It was for years in Laguna Niguel in Orange County, California. And last year, when we relocated up here to Lake Arrowhead, we relocated the haunt with us. It's a nonprofit. Happy to talk about nonprofits tonight. How to obtain the status, how to obtain 501c3 status to help you with the IRS, because all corporations start out in their states. You have to incorporate in a state and then operate for 2 years. Then you can apply to the IRS to become a federal nonprofit. That's what everybody's looking for. Our haunt is in an abandoned schoolhouse. It's about 4,000 square feet now, and we're up to about 30 actors, and we're open for 2 weeks, just right before Halloween.
Excellent. Well, since we're talking about nonprofits, let's go and answer that question. How do we get started as a nonprofit? And guys, if you're out there listening in the chat room, go ahead and ask your questions as well. We have some that we are going to ask Matt, but please leave it in the chat room. We'll get your question answered.
Sure. Now, I want to start off by saying I am licensed to practice law in California and Texas only. So what I'm giving you here tonight isn't legal advice. It's more legal observations. Nonprofit status brings with it good stuff and bad stuff. And the bad stuff we'll start with first. That is record keeping. Record keeping is a yearly thing that you have to do. It's always best. When you're becoming a nonprofit, the accounting information is incredibly important because that's what the taxing authorities look at. What's your income? What's your outgo? Another bad thing about becoming a nonprofit is not just the record keeping, but the reporting that goes along with the record keeping. And you are subject to audits very, very quickly. The state can come in and give you 2 weeks notice and say, okay, we're going to audit you. That is a very rare occurrence, especially if you're just starting off. Now, some of the good things that go along with being a nonprofit is first, it helps very much in getting actors. If you have actors in college or high school, they all need public service credit. Being a nonprofit corporation, you offer that to them, whether they need it or not. It's something you can always sign off on for them. You get the protection that a corporation brings so that you're not personally liable for any of the corporation's debts or obligations. You get more exposure by being a nonprofit because people can look you up in the state government. They want to, and we have found that more sponsors are interested in coupling with a nonprofit than when we were just a home haunt with no status, no corporate status. So having the nonprofit entices businesses to come in and work with you and do the big thing we're all looking for is donate, because they get special tax treatment out of what they provide, whether it's money or services. And also putting up signs of some local businesses that have been around for a long time and are well respected. That just brings more media, in other words, to your haunt. They will often run, hey, we're sponsoring this haunt at this time on their website. They'll put their signs up at your haunt. And again, that can give you instant credibility if you're just starting out, or add to your credibility by saying, look at how many people in the community support us.
Right. So how do you get established doing that? You got to fill out a form or talk to somebody, or?
You don't need to see a lawyer. I highly recommend you do. There's the service that everybody knows of by now, LegalZoom. LegalZoom can prepare the documents you need. Every state has a pre-printed form. You fill that out, and that consists of what's the name of the company, what's your address and all your contact information, who are your officers, the president, the vice president, secretary, and who are the directors, the members of the board of directors. They can be this one and the same. And I can tell you for anyone listening in from California, New York, they have certain pledges that you have to sign, including in California and New York, that you strive to put a member of the LGBTQ community on your board. Those pledge requirements have been stricken by courts because they're unconstitutional. The government cannot force a private business to have a certain type of person on the board. The government just can't do that. So there are the forms you fill out, and then every state has a fee. The two highest are California and Nevada. In California, it's $800 a year to be a corporation, whether you're for profit or not. And in Delaware, it's $1,100. Nevada and Delaware are the same at $1,100. They are two very corporate friendly states. But for purposes of what we're doing, you just simply fill out the form and file it. Then there's going to be a series of documents that the nonprofit division of the Secretary of State's office is going to ask you for over time. And it's mostly how much money did you make and where does it go?
And you have to show proof that you're working. Do you have to have is there a charity component of it? Does it have to be a charity, or are you?
It doesn't have to be a charity. And no, most states will just have you fill out a form online, or you print it and sign it and send it back in. And you swear under penalty of perjury that your operations are conforming to the nonprofit rules of your state. Mm-hmm. Unless there is some investigation by an attorney general or a taxing authority, that's sufficient. What you have to make sure of, though, is to keep those records. You generally don't send them in, but if you ever get audited, they want to look at them and they have to be complete. That's not something you need to hire a lawyer for. That's something you can just teach yourself by going to your state Secretary of State website. They all have facts and explanations of what do I have to do to keep myself current and in compliance with law.
Very good.
I think Scarrett badges are one of the smartest things I've seen in the industry in a really long time. Scarrett badges are basically either pins or embroidered patches, kind of like merit badges, as they are, somewhat named after, from Boy Scouts and Girl Scouts and Brownies, and where after you've accomplished something, you can wear the brag tag of the embroidered patch. Some haunts put them on jackets, some put them on t-shirts, some put them on, with the pins, I've seen them put them on lanyards. But the neat thing about them is they are very specific in what they are rewarding. And they're haunt-based images that reflect what's being rewarded. It's retention, it is bringing people back, and it's actually giving your haunters, your haunt performers, the ability to share that they are haunt performers. And, oh really, you're a scare actor. Where do you do that? And then they will insert the name of your haunt right there. So it's also marketing. I've always been a big fan of Scarrett badges. I think they're great. So check them out, scarrettbadges.com. No, that is not a paid advertisement. That is just my recommendation. I think it's really cool.
ScottSwinson.com.
Now, you said the two states are $1,100 and California is $800. What is kind of the average for some of the other states?
It averages out to be $350 to $450 if you put everybody together, because some states have such small corporate bases, like South Dakota. The higher the population of the state, the more extensive the record requirement and the more expensive it will be. In states that are lower populations, they're dying to have some corporate activity, so they make it very, very friendly.
Okay, good to know.
Let's talk about, I know we were doing some stuff before we got on here. Let's talk about using waivers in haunted houses.
Yes, waivers is a great topic, and that's a question that I get asked a lot. I cannot urge you enough to use waivers. If you're using time ticketing, they are great at incorporating your waiver into the purchase process for tickets where right before somebody can click purchase, they have to click I read and agreed to the waiver. Virtually every state enforces waivers in favor of haunted houses. Essentially, it is assumption of the risk. You paid people to scare you and they did their job. You get what you pay for. So if customers come through, they get scared, they take off running, they fall down. Most judges will look at that and say, well, you paid for a scare and you got a scare. And the fact that you fell and hurt yourself, under this waiver, they disclosed to you ahead of time, before you went in other words, that not to run, to keep moving through. And haunts do want to make sure that they have clear flooring to avoid slip and falls, but it happens. And having that waiver is the first thing you need to show. Before a claim comes in, you need to show your insurance company. They're going to ask for it if you use waivers. If a claim comes in, you need to have that waiver and have it executed. So we have 2 sets at our haunt. The first set goes through the time ticketing. That's a PDF version. And then we have written versions at the haunt. So we'll have people sign them right there if they're walk-up cash payers. And in addition to waivers, and anybody that wants a waiver, if you go to, if you drop me an email at Matt, M-A-T-T, at themurphylawyers.com, I can send you examples of different waivers. But I strongly suggest, this is one place where I do recommend you hire a lawyer to look at the omnibus type waiver that I will send you, and compare it to your individual state's laws. Have that lawyer look at it and make sure that it covers everything that your state law requires it to. And in conjunction with using the waivers, we talked about having rules that are simple. When they become 40 rules on a sign outside, it becomes cumbersome. People look at it and they look away. I suggest that you take your top 10 rules, put them on some kind of a board out front, and we'll talk about cameras when you're ready. But what we do and what we recommend that haunts do is have a camera stationed right outside the entrance, have your door person ask everybody in the group, did you read the rules? Have them all give you a nod or a yes that's audible, and then send them in. If you put the 10 rules about don't touch anybody, don't touch anybody and you won't get touched, that kind of stuff. That's the biggest issue that I think most haunts have, is people coming through and getting physical with actors. That should be bolded, number 1. Don't touch actors, props, scenery, anything like that. If you get those folks on camera nodding their heads that they read the rules, they go in and break them and then come out and say, hey, something happened in here, I want my money back, or I want the name of your general manager, I'm going to sue. You not only have the waiver form, but you have the video of them acknowledging what the rules were.
Okay, Tammy's got a question. What do waivers not protect against? What are their limitations?
Mm-hmm. Waivers protect everything that is negligent. Waivers generally do not protect volitional or intentional acts. So if an actor hauls off and hits somebody or throws something at them, that's a volitional, intentional act, and both the actor and potentially the haunt may have liability there. But anything that is a result of mistake, waivers will cover that. Mistakes by the haunt, mistakes by the actors, mistakes by the parking people, anything like that is covered. And you can even write the waiver so that it covers just less than what's called gross negligence. And that's where if somebody knows there's some kind of caustic material in the scene, or in a scene or anywhere in the haunt, and somebody comes in contact with it, courts can find that to be grossly negligent based on the caustic nature of the material. If it's acidic or something like that could hurt somebody. But when it comes to blatant gross negligence, there are oily rags right outside the door, and people smoke. Somebody flicks a cigarette in it and it goes up. That's gross negligence that won't be covered. And if somebody does something volitional like an assault, that won't be covered by the waiver either.
Good. I hope that answered Cammie's question to her satisfaction.
Well, that kind of leads into insurances. What types? What do we need to cover our own butt?
Let's first talk about insurance in this way. Insurance is essentially you purchasing a defense against the lawsuit. An insurance company must put up lawyers to defend your company, it's not your personal expense. It's paid for by the insurance company. And more than often, that is the most important part of an insurance policy, because once lawyers get on board to defend you, unless there is a lawyer representing the complaining party, often that will result in the ending of the case. But litigation is very expensive. No haunt has a core competency of being a litigator. It's not something they do. So it can drain you very quickly. Having the insurance company pay for the lawyers will help. The second part that insurance gives you is, of course, indemnity. In case there is a judgment against you, the insurance company pays out. But that is the most important reason that I push for everybody, even home haunters, to obtain these policies. We use Granite Insurance. There are several insurance brokers. HAA has a listing on their website of insurance brokers. There are some that sponsor certain things, like at Transworld, so you may see them more prominently. But really, any of these specialty carriers, they all go to the same. They all go to Lloyd's of London or different services like that to cover the losses. So the insurance, we used to pay $350 for 3 days of $2 million in coverage. Those days are long gone. We generally budget out $1,500 a season to get general liability insurance for the haunt. Those kinds of insurance, which company, I'm not affiliated with Granite, but this is, we started off with one insurance carrier, and they decided not to sell policies that had premiums less than $5,000. So we moved to Granite. They cover everything from workers' compensation claims to your actors getting harmed, to any kind of property damage, but especially people who get harmed in the haunt or in the haunt's vicinity, right outside any of the property that's owned or rented by the haunt. And they are invaluable. Every year I get calls or emails from haunt saying, hey, I just got this letter from somebody who claimed last month they got hurt in the haunt. And my advice to them is usually just let it go. Don't respond. If they know that there's a live body on the other end, there's going to be negotiation and some money paid out. If people don't, one of the things that you must put in your waivers is that if anybody is harmed by anything while they're going through your haunt, they must report it immediately. Upon leaving the haunt, they have to find somebody who works there in management, or even just the person who's working the outside, and make the report. If they don't, it's deemed waived. The claim is deemed waived. So that's a very important part that you put into your waiver. And the insurance company, you will start off at premiums depending upon, again, the size of your haunt, how many people you put through, what your gross sales are. That's they base a lot of that on. you'll pay $1,500 and higher for the coverage, but it's peace of mind. And I have worked with haunts that had to make claims to insurance. The carriers are generally good. The only thing is, if you make a claim, you have to disclose it in every subsequent year that you're going to buy a policy. If you've had a claim made and the carrier has had to pay out, you're going to pay higher premiums. That's no different than if you're in a car accident. You're going to pay higher premiums for car insurance in the future. So we try to handle things. We're lucky because my wife and I are lawyers. We were able to deal with things, and we've never really had one. But there are some catastrophic things that happen in haunts, and having that insurance is what you need, because otherwise it'll drain you and you'll end up in bankruptcy court.
Do you know what causes haunted attractions to shut down before they even get started? The top 3 roadblocks are lack of funding, lack of leadership, lack of resources. As a member of the Haunters Toolbox, you get instant access to the tools you need to start and grow your own haunted attraction business. To get started, become a member at haunterstoolbox.com. And how long does that stay on your record? Like if you file a claim, does that stay on
5 to 7 years?
5 to 7 years?
Yeah, but they're always going to ask you on the form for your loss history. And if you're changing carriers, they're going to want a letter from your previous carrier establishing your loss history. And a loss history is simply how many claims were made and what loss was paid out.
Right. The Cammie was asking about the waiver again. Could extreme traumatizing content be considered grossly negligent?
If I understand her question correctly, is a feature, if the feature of the haunt is too
maybe like an extreme haunt or touch
haunt. Yeah,
an
extreme haunt. Generally, yes, it would cover that because nobody's getting physically touched. The real problem is when people are physically touched with anything other than air. If they're hit with water, like a spitting animatronic, you have to be very cognizant of what the water is in there. But air blast scares, those are all covered. But once you get into the subjective, one person may think that that's horribly frightening, and another person may say, not so much. Once you get into the area of subjectivity, you're beyond what the law controls, because everybody has their own opinion. If they get upset by something they see in the haunt, usually there's a boo hole or somewhere that you can get them out if they're really so traumatized by it. But once you get into subjective opinions, your waiver takes over. There are some, there are touch haunts that are not McCamey Manor. There is a haunt in Chicago and there is a haunt in New York, and they don't bill themselves as haunted houses per se, but it's a great, it's an overnight stay in a very scary place where actors run at you, but things happen. If you run a touch haunt, I guess I should have made that clear. If your haunt allows actors to touch, you're going to pay higher insurance premiums. There's just no two ways about it. And if you have a touch haunt, you want to make sure that you see a lawyer about getting a waiver that will cover that in your state. Courts generally have said for decades now, if you go to a haunted house and get scared and fall down or hurt yourself, that's on you, unless there was something inherently unsafe about the haunt. The touch haunts, the courts are still split on it. Most courts are holding now that touch haunts, touching means the exterior of the body. It's where you got to start worrying about getting more intimate areas if your actors touch people's necks. And there should be no touching below the belt. But still, you're taking a bigger risk as a touch haunt There's really no overarching legal advice that can be given to you. It's all going to be based on the facts of the case, but just know you're going to have a need for a very, very clear and encompassing waiver, and you're going to pay higher insurance premiums.
Let's roll into for home hunters out there. Shane was asking, how'd you cover yourself from people bypassing your fence to do damage in your home hunt or yard display?
The best thing to do for something like that is to have a course map, have it on your website, have it on the have it right by the rules sign as people are walking in. The trail through the scenes should be readily viewable and accessible. If somebody goes off the beaten path and causes damage, well, now you have an action against them. But we don't want any of the haunt experience to end up in a courtroom. That's just not going to be good for the haunt. So the key there is make sure they can't get into areas that they're not supposed to be in.
Well, so it's typical, like if someone comes in your yard, home haunt, destroys your stuff, is that covered by insurance?
Yes, if you get the policy ahead of time, they will cover. The policies generally cover set damage. You can never get away from the fact that every home haunter out there, and even the guys that have turned pro that started home haunts, you're inviting people onto your property and you're not a commercial organization. So essentially, trespassing laws apply to you. And that's about it. Because when you invite somebody onto your residence premises, it's different from being open to the public like a grocery store would be. Anybody can walk in there, but you're inviting people in. So if they smash up your stuff, I think all of us who have worked the front have some kind of sense of people who are going to be problematic. I was taught to go to people and say, ones that were really drunk or boisterous, say, hey, maybe tonight's not the best night for you to see the haunt. How about I give you a set of tickets for tomorrow? Other than that, we will send people through with them. We have people that we can just stick into a group and follow them. And if there's any problems, security will come in.
Mm-hmm. I used to follow them with my egress. I had an egress that went all the way around it. I was like, just spying, checking on them.
Right.
Just waiting for them to mess up. I was like, I'm just waiting. I was busted with my flashlight right in their face.
Right.
Yeah, you're coming out. Come on. But another thing about home haunts, I get a lot of questions about, do they need special insurance to have like a walkthrough in their garage, or is that different than a walkthrough in their front yard, or do they need an extra policy? Or
homeowners policies and renters policies will not cover any kind of haunt, a home haunt that charges. If you don't charge for admission, there's a better argument for you to make that your homeowners will cover it, but it's really bad practice to rely on your homeowner's insurance or your renter's insurance. It is best to just come out of pocket and get that specialty coverage. Your homeowner's insurance would just put you through the ringer with questions and things about, was this a profit-making endeavor? And even if you're a nonprofit, using your home as for a haunt, ultimately you do have to tell them we take donations. Insurance companies will say, aha, donations, you're doing this for profit, it doesn't cover it. So to avoid those headaches, just get the specialty insurance and you'll be covered stem to stern.
Okay. Darryl, what other questions we have on that list?
Well, we've kind of talked about insurance and stuff to cover yourself, but what kind of things do you need to deal with your employees, whether that's your actors or the people who are doing the build crew or your management or security team? Any special things that are needed in the legal realm for your HR, for your employee relations?
Well, I can start with a story of my brothers at 916. They run Purgatory Scream Park in Houston, and Texas 4 years ago, just like most states are doing now, reclassified independent contractors to seasonal workers, meaning the state still gets and the feds still get their chunk out of what's paid to the actor. So what I strongly recommend is to see a lawyer in your community to tell you whether haunt actors and the other people who work for you, if they're not full-time employees, would they be considered by the state's law independent contractors, or are they seasonal employees? In many states, if they're an independent contractor, virtually all states that recognize that, you owe them nothing other than what the hourly wage that you told them, or nightly wage that they would be paid. If they're seasonal workers, most states will require workers' compensation insurance. That's another expense for a haunt. And they are covered generally by disability, state disability, whereas independent contractors are not. Irrespective of whether you employ seasonal employees or use independent contractors, the most important thing is to have everybody sign a written contract every season. And in that contract, you want to explain the most important thing to have in there is the code of conduct. What actors, tech staff, front staff, management can do and what they can't do. Most of the disputes that we see among haunt employees and haunts is the haunt employee saying, "You never told me I couldn't do that." Well, if they signed an agreement, they don't have that argument anymore. And to just make sure that the understanding between haunt ownership and haunt staff and actors is clear from the beginning, have that contract signed. Once the hiring decisions are made, we recommend having all the actors come in for a 1 hour or a half hour meeting to have them all sign their agreements, and then have haunt ownership go over with them that contract. Here's the things you cannot do if you are employed at this haunt. That's generally what I want to see in those contracts, is what they can't do. What they can do is act and scare people and be good teammates. But what they cannot do must be spelled out in that contract. So that way there really is no dispute. An actor is reported as being late, or work on their phone, or just leaving their area. You can give them warnings. It just depends on you. You can give them warnings, or you can fire them on the spot. And if there's any issue, you can say, well, please consult the contract you signed at the beginning of the season. We told you can't use your phones in your area. You can't leave your area unless a supervisor or your team member knows, so that your area can be covered or appropriately avoided while you're out, whether it's a bathroom break or whatever it is. So having contracts are just paramount to having good relations with your actors.
Yes, they are a must.
And we see more and more smaller haunts using them, and that is just great. Every haunt, regardless of size, unless it's your kids and only your kids, then there should be a contract.
This podcast episode sponsored by Scarlet Badges.
We always were looking for ideas to get those actors to take it to the next level. I really want to do something that they can use more than just a meal, or they can use more than just a that a boy, that a girl. They love this stuff, but it's not really promoting a haunter. And then I sit down, Scarlet Badges comes out. That's when I realized this is amazing, because not only is it giving them an attaboy, but it's also promoting them all year round. And to promote somebody, to give somebody accolades all year round and have them be able to wear it on their shoulder with pride means a lot. This right here says this is who nailed it on this day in this year. for the rest of their life, for the rest of their haunting life. And that's what I really love about this product is you're able to give haunting to somebody, an attaboy, 365 days a year. And that's, so hats off to you guys. I think this is a great product and I wish you the best of luck because it's awesome.
Get your scare badges at scarebadges.com.
The other thing that should go into those contracts, and this is another issue that we have come up regularly, is the haunt characters belong to the haunt. Regardless of what actor is filling a role, that role, no matter how well the public associates that role with a certain actor, it always stays with the haunt. And that has to be spelled out in the contract. That even actors that come with their own shtick, their own character, you want to have in the agreement that, okay, if it's your character and we've hired you as your character, we don't want you to say, come see Cyclops at XXX haunt. You can do your social media and promote your character and say, I'm now at Scream World. But all that intellectual property should stay with the haunt. So if the actor goes, the character stays, especially if it's a favorite character of your fan base. And the other issue is promotion of individual actors on social media. That should be spelled out in your contract as well, that if they are going to promote themselves, you don't want to have things say like Choppy the Clown exclusively at Dead of Night Haunt. If anything, you want to just say, here's this person, I'm here at this great haunt this season, come see me and come see the haunt. That is, there are many haunts that have signature characters. We have a signature character in our Wraith, and this will be our first year where we had an animatronic Wraith built. But those kinds of things should be put into the contract so actors know when they leave, they cannot be that character again. The only way to be that character is if they're working at your haunt. Otherwise, they got to come up with something else. You should also have social media policies. We talked about this before, but haunt actors are different. Is a different breed of folks. So you want to make sure that they don't put anything on their personal social media accounts that will drag the reputation of the haunt down. So what we recommend is putting in the contracts that if they are going to post about their appearance at the haunt or something that happened at the haunt, that should be approved by ownership first before it goes on. That's easier said than done. But there should also be a policy in there is if we come across something in your social media that we deem to be detrimental to the reputation of the haunt, we can direct you to take it down. And you have no choice in that. You either take it down or you're out.
I can see contracts being a evolving thing as you experience things year to year. Like we need to put that in the contract next year. So it just kind of keeps, do you have any examples of contracts or a way to get a hold of?
Yes. If you shoot me an email, I have contracts for the state of California, Texas, Florida, Ohio, Virginia, and Alabama.
And that's Matt at
murphylawyers.com.
Okay.
Now, we've been talking about contracted employees, independent contractors and stuff. What kind of laws and rules are there around volunteer staff? Do they need contracts as well? And how does that work?
I do recommend that even volunteer actors sign an agreement, because they're told the very same thing as your paid actors. They can't engage in certain activities. They can't smoke while they're on the course. Communication, we talked about this. Communication is huge, and it starts from the day they're hired. And that contract is just invaluable at communicating to them, here's what we expect. And for volunteers, another issue comes up. With paid actors, again, this should be in the contract. You want to have media releases. so that you can use anything about their character or what they're doing in the haunt in any media that you want. That should also be in a contract for volunteer actors. You want to be able to use anything that the haunt records in any kind of medium. And we learned it's not just advertising. In 2021, we were the subject of a documentary called Halloween Obsessed Haunted Attractions. They used in that in the ultimate final product that was the documentary, they used footage from our film, but we also did a background video to kind of give a story about the haunt. Those actors that we hired for that role and the kid we hired from University of Chicago Film School to shoot it for us, they all need to sign agreements as well. So you have that media release. You want to own every bit of intellectual property that comes out of your haunt. That's not just your name, your signage, signature characters and things like that, but anybody who's around the haunt that is affiliated with the haunt, whether they're an employee, an independent contractor, or a volunteer, they all should be told at the beginning, you are likely to be subject of video recording and you're assigning your rights to the haunt so that we can use it however we want it to promote.
Speaking of characters, so what do you think about haunts using trademark characters without paying licensing fees? Or what are the risks if you do?
You're walking into a hornet's nest. Just know at the outset, you're walking into a hornet's nest. Now, I have represented a union called ASCAP, and ASCAP is a clearinghouse for musicians to get paid royalties. And ASCAP will even send people out to bars who play music to see if they're playing any kind of covered tunes, because if they are, technically ASCAP gets paid and the musician that wrote the song gets a royalty. So if you're going to use a trademark character, and there's only two that I have ever been approached by haunt saying we got a letter. Art the Clown is big. And the other one, I can never remember the name of this. Somebody's going to have to tell me, but it was for a Stranger Things series. They had a character that had a very distinct face. And the reason this one came to me is there is a mask maker in California who was asked to make this particular mask to make a character from the show. We were concerned we were going to get a letter saying, hey, that's our copyrighted character, either stop it or pay us. And this is the way that you can gauge the potential problems that you would have. This is the phrase, money makes people do stupid things. So if you're going to use a character from a horror movie and you're a $3 to $6 million a year haunt, you can bet they're going to find out that you're doing that. You're going to get a letter. If you're a small haunt that is open in October, it's unlikely, because the money that a haunt would make, the copyright owner is still only entitled to a reasonable royalty. That would be a fraction. And if somebody does $500,000 a year gross, and that one character is one scene, courts will go through and divide up, okay, how many characters did you have? 50. Okay, this is 1 out of 50. So they'll try to monetize what that character did, see if it's reasonable, and then say, all right, you pay them that amount and don't use that character again. That's more money in attorney's fees than a movie house would ever pay to probably get a check for $1,200. It just doesn't make sense to them. So I don't have a problem with it, but just know you're walking into a hornet's nest, and the more money you make, the more the movie houses are going to be looking to take a chunk out of your rear end.
Do they usually send like a cease and desist letter first, say just stop, and then we'll go from there? Or is it?
Yes, the law has evolved so much that cease and desist letters can be a liability for the person who sends them. What they generally send are inquiry letters. we have reason to believe that you are using this particular character either in live performance, certainly on advertisements. So we'd like you to respond and tell us if that's true. And then if it's from a lawyer, they'll usually say, also give us your gross receipts for the year that you used that character in your haunt. Because then the lawyers are going to come back and say, oh, the Copyright Act has an attorney's fees provision in it. So if we sue and win, we get our attorney's fees. They'll make some kind of ridiculous offer. And usually what I'll do is if a haunt brings that to me, I'll write back and say, oh my goodness, what a mistake that was made. It was all well-intentioned and it was a mistake. So we're just going to pull the character and not use it anymore. And we never respond, and don't ever respond if whether it's a lawyer or another business owner says, well, tell me how much you made on my IP, because you're just inviting a lawsuit. It's just better to say, whoops, our bad, and take the character out and move along smartly.
Does that still count if you buy your Halloween costume of intellectual property from the dollar store or, Temu or whoever that already has these masked killer instead of Jason or Michael?
Yeah. Those things always skirt the very fringe of the law. They do whatever they can to say, well, if we make this change here and this change here, maybe that will be enough. And I hear also people come to me and say, well, it complied with the 10% rule, or it complied with the 15% rule. I'll say, what do you mean by that? Well, we changed it 15%. So there's no percentage rule. That's not the way that courts analyze whether something infringes. That generally it comes down to, is there a risk that the public would see the character from the movie and then associate the character in the movie with that haunt? Changes can help, but that's not determinative. So if you purchase something from a mask maker, Spirit Halloween, something like that, and you get a letter, you go back to Spirit Halloween and say, look what I just got. I bought my mask here. If I get sued, you guys are paying for it because I just bought something for you. Spirit Halloween and some of the bigger places like Home Depot, if they are using characters from a story, they are big enough, they generally must get a license.
They get the licensing for it. Right.
Any small mask maker, and really every mask maker in our industry is a small business, they generally won't get licenses. So if people start saying, hey, I got a letter from some company after I bought your mask and wore it, they should take care of you. And that is, okay, we'll send you a new mask, or pick one out and we'll send it to you and you can send back the other mask. You just want to keep yourself out of harm's way that way. And the more exposure your haunt gets, the more likely you are to get a demand letter or an inquiry letter.
Have you checked out HauntersToolbox.com yet? It's free to join and full of useful information to help you start and grow your own haunted attraction business. All the information on HauntersToolbox.com is created by the pros who do it. We have a library with ebooks and presentations on topics like creating an employee handbook, starting a business plan, or the best types of lights to use at your haunt, plus a lot more. You get instant access to the library plus free video masterclasses by the experts in the haunt industry. Classes like Alan Hops from Dark Hour Haunted House teaching scare acting, or Philip Hernandez from the Haunted Attraction Network teaching marketing and social media, or Leonard Pickle from Hauntpreneurs teaching haunt design and construction. I even got a few master classes in there as well. You don't have to do it alone. Let us help you. We also host monthly live master classes to steer you in the right direction so you don't get lost. Once you become a member, you also get instant updates on our next master class in your email so you don't miss the next one. And if you need more one-on-one help, there is an option for that as well. I would be honored to help you get your attraction started or help you grow your current one. I know what it takes. Let's talk. If you're interested, you want to start and grow your haunted attraction, go check out HauntersToolbox.com Don't be scared. Yeah, I've always heard don't advertise it. Like I'm a mid-size haunt, but my dad was Freddy because he wanted to play Freddy, right? So he had a silicone mask and the whole bit. He was in a dark alley. We never advertised it. It was just something. No one said anything. So
Right.
he doesn't play
You
it
call
anymore.
attention to it, it's gonna end up in front of the wrong person. So if you're going to use characters like that, know that again, it's a risk, but you can put them in the haunt just so long as they're not the face of the haunt.
Right. Don't make it a big thing,
Right.
Someone was asking, I think it was Shane Helmstetter, talking about influencers that post stuff about your haunt on social media and stir up drama. Can you do anything about that?
It depends. If influencers are always coming out saying, "Hey, I'll promote your haunt. You give me free merch and free trip through." If you have some that are causing any kind of drama and they're dragging the name of the haunt down, that's called trade libel. Trade and libel, trade libel. It's a defamation of your company's name and reputation. You can hit them with a demand letter to say, stop talking about us. We did our deal. You got some merch, you got free tickets, you promoted us, but now you're starting to put false things on the internet, and that's when we're going to have a problem. You don't need a lawyer to do that. You can write the influencer directly and say, hey, can we come to an agreement here that you're not going to put this stuff up anymore? I always recommend let the lawyer be the bad guy. Courts always look for businesses who are the most reasonable. So when you reach out, just say something along the lines of, we've heard, it's been brought to our attention that you've been broadcasting X, Y, and Z about our haunt. We view that as a defamation, and we'd like you to stop. Can we get you to stop? And if the often influencers will put the letter on their site, on their social media to say, hey, look at these people, they're threatening me. That's why the first letter should always be, hey, can we reach an agreement on this where you're not going to do it anymore? If not, let the letter come from the lawyer. And people know lawyers write letters to tell people to stop doing something or start doing something. It's not going to hurt the haunt as bad as if you're a haunt owner and you get hot-headed and you write a very terse letter, let's call it. That could end up harming the haunt if that gets put out on social media. It's just better to try to be reasonable. And if they won't be reasonable, hire a lawyer and he can be unreasonable.
Now, one of the things we sometimes hear, somebody posts a bad review about your haunt or something specific that happened in your haunt. What's the best way to handle those in a situation like that, where it's not somebody you've paid, it's somebody who's paid to come to your haunt, and for whatever reason, they are dissatisfied and try to blow it all up?
Mm-hmm. A good strategy that I've learned from other businesses is to first reach out to the reviewer and say, hey, if we give you a free ticket back in and some merch, will you take your review down? Sometimes that works. If not, respond to it. Don't let any poor review go unresponded to. Respond to it and generally say, hey, thanks for your review. Sorry you had a bad experience. We'd love to have you back again because we're always striving to earn our customers' business. So just try to be as polite as you can. Everybody knows you always have people who will complain for one reason or another. Just be the most reasonable brain in the room and you'll be okay. If you start getting a number of bad reviews, it's time to take a hard look internally to see what's causing that. But if it's a one-off here or there, see if you can get them to take it down with some free stuff. And if not, respond to it. Say you're sorry that they had a bad experience and you look forward to them giving you another shot.
Yeah, because customers are smart. We know when you're looking at reviews and how they're worded. Oh, you scared my 10-year-old. I'm like, Well,
That's what
actually,
you paid me to
we
do.
were trying to.
Yeah, and we also posted out front that we recommend it for 12 and over. And if
Right.
you brought your 8 or 10-year-old, well, whose fault is that?
Yeah.
Mhm. Didn't read the rules. Hmm. Speaking of rules, what do you think about just signs plastered everywhere? Are they without a waiver, just signs, top 10 rules and go? What kind of
If you do that, again, whatever you can do to protect yourself, the more you can do, the better. But if you don't, you're not, or you're in a state where waivers maybe aren't as effective, or the way that you run the front is not conducive to waivers. Get that top 10 rules, get the camera on the people, make sure that the person running the door gets everybody to say, yes, I read the rules, then set them loose.
at least you have
That gives
something.
you
You have
some
something, right?
protection.
What about video cameras in other rooms and protecting access?
Those indispensable. I can't recommend to folks enough. Ring cameras have come down in cost so much. And we found out that if you pay $10 a month, you can take the cameras wherever you want to take them, and Ring will keep the video for, I think, 6 months. If you use them off site, you have to record it without paying the $10. If you use them off site, you have to record it yourself. And that's just a real pain. But having video evidence of your haunt, videos don't lie. So the police, judges, they will go with what the video shows, not with what the people say, insofar as making a charging decision or a filing decision. So video cameras for defense of the haunt are invaluable.
Because usually, if you mention, like you were saying if earlier, hey, let's go back and check the camera out, and we'll decide what happened, and then usually take off, and you never see
Right.
them again, right?
That is a very effective tool of saying, well, I'm so sorry that happened. We have video of every inch of the haunt. Tell me where it happened. Let's go look at the video. And 9 times out of 10, nothing occurred. And they will disappear.
Yeah.
Now, things that we would like to disappear, let's go back to our home haunters here for a little while, because we have quite a few home haunter members on, that we know of. HOAs, how the hell do you deal with an HOA and, during your seasonal event? Because sometimes they're haters.
Very much so. And some neighbors are haters that will make sure that the HOA gets aligned with them. Here is the general rule for HOAs that say you can't run an operation in the neighborhood because it's disturbing to our members. There's really only 2 things an HOA can rely on to shut you down. One is increase in traffic. So having a parking and traffic plan, very important if you're going to take on the HOA, because they can take the position, well, we don't have the flow of cars through these streets on non-haunt nights, but when you're open, we get all this congestion. We have kids in this neighborhood. They could get hit by cars that aren't in this neighborhood. So having a parking and traffic flow plan is highly important. The second thing is, unless you are permanently changing the exterior of your home for your haunt, generally an HOA will lose. If you're only open for a few weeks to a few days out of the season, and you strike your haunt when it's over, it's all gone and the house still looks like it did before the haunt, the HOA doesn't have a leg to stand on, because in order to enforce the CCNRs, you have to make a change that is permanent. If it's something that is transitory, is what the word that courts use. If it's transitory and it doesn't permanently change the appearance, it is not a violation generally of CCNRs. The way to avoid the commercial business exception is to become a nonprofit. That was a big motivator for us, is because we got a letter from the HOA saying, we view your haunt, even though you're taking donations, we view it as a commercial enterprise, and HOAs can lawfully forbid you from running a commercial enterprise out of your home. If you become a nonprofit, they have no leg to stand on. You can just say, well, it's not a commercial venture because it is a nonprofit. Our money is the proceeds go to a certain charity or organization or some for the benefit of some people or entity, and that's the net proceeds. You still take all your expenses out of what money you bring in, and then you send a donation afterwards. So the three things: don't change something on your property permanently that is for the haunt. Make everything transitory. It goes up like a decoration for Halloween and it comes down when that's over. The second thing is have that parking plan, and that may mean having people park off site and come in to the neighborhood. You can run a bus. That's a liability raising event, or you can just have them park on various streets. Always have something in your parking rules. Don't block our neighbors' driveways. That is a real big one. That usually is what brings in the most calls when people can't get in or out of their driveway. And the third thing to defeat the commercial challenge is to become a nonprofit.
Makes sense. Oh, we have a couple other questions from Facebook. So about the videos, do you have to keep the video a set amount of time? Like, what would you recommend? Downloading it somewhere and having it?
Yeah, but for smaller haunts, I recommend they keep them 3 to 6 months. For larger haunts, larger mid-size to very big haunts, they usually have their own internal recording equipment, but I advise them to keep their video at least a year, and 2 years or better. The statute of limitations for a negligence claim in every state is generally 2 years. So you want to keep that video while the statute of limitations is running. And once it's run out, then you can get rid of the video or record over it.
Right. Just go ahead and download it on I use Dropbox, and just keep it in a little safe folder somewhere just in case you got to.
Just in case.
Pick it up later. Right.
Yep.
Okay. Anna poses a good question here regarding Americans with Disabilities Act, the ADA. If it's an outdoor trail haunt, what level do you need to focus on complying with ADA?
If it is a for-profit haunt, you must comply with the ADA. If it is a not-for-profit haunt, it's something that is, again, transitory, done in a house. She's saying a trail. If it is a haunt that is sponsored by any other club like the JCs or the Chamber of Commerce, the ADA is generally inapplicable. And for outdoor haunts, you can say, and I recommend you do say both. If you use a ticketing site, you put it in the terms and conditions of the ticketing site. And if you have a website, I would put right on there, we unfortunately are unable to accommodate wheelchairs on the site, or any person with a walking disability that can't walk a certain length, a certain distance in a certain period of time. We strongly recommend that you don't attend, but if you do, note that there's nothing, we have no facilities to assist you in going through the haunt. We had issues with some very, very elderly Halloween fans that wanted to come to walk through our haunt when we were a home haunt, and we had all kinds of uneven terrain, just like anybody's yards have uneven terrain. And we told them politely, we can't take you because this particular woman used a walker. He said, if you get through, there's gravel, there's whole areas of gravel, and that thing could slip in between stones and you take a spill. So we just say, unfortunately, we're unable to provide assistance for that. And you're open to the public, but you're also seasonal. So you're going to be, and if it's not a permanent structure, the ADA wouldn't apply. And it's so long as you give people forewarning that, hey, this is uneven terrain, We can't guarantee that it won't be wet. It could be raining. It could be after the rain. And it's very slippery because it's a trail. We have no assistance available for customers who want to go through, who use any kind of aid or assistance in walking.
Okay, good to know.
We have RJ, do we need to have it posted that we are recording you if we have cameras in the haunt?
Yes, it's always important at the outset, right where somebody walks in. Put it this way, the first camera that they would appear on, if that's when they walk through the line to the front, if that's your first camera, then right there with your list of 10 rules, you can put number 11, or you can put a separate sign, video surveillance used. And that is, it doesn't necessarily mean they will be on camera, but they're being surveilled, and they may appear in video.
Very big old bright yellow sign. You are on camera. Smile.
Yes.
Yeah.
Mm-hmm. That's also a good warning for people not to screw up in the haunt.
Right.
Because you tell them we're watching you.
It doesn't always help.
No.
Nothing's foolproof. I know.
Yeah, they just keep making better fools.
Yeah.
Dave, I was asking, have you looked at haunt application forms? I have reviewed thousands, and they are asking legal questions such as date of birth, allergies, gender, felony convictions. What advice do you have about that?
If the application forms are for employees, note this, that President Trump signed an executive order that removed all LGBTQ and gender specific language. That all has to be removed from federal agencies. Well, private business is following that because private business knows I'm not going to go do business with the government if I have practices that are forbade by an executive order. So everybody is trying to come into place with that. Date of birth on an application like that is a fair question. Gender, I would completely avoid. Allergies. So if you're not selling food or making food available to actors, that really wouldn't.
What about latex allergies for using latex masks? That's important.
Yeah, that should be disclosed even in the contract that you use with them. We use latex. It's unavoidable. If you have an allergy, you must tell us at the outset. That doesn't mean that they have to be terminated, but you might have to put them in a scene that has absolutely no latex at all. If I understood the question correctly, that sounds like applications for employees. I wouldn't dig. Most states have passed laws now that you cannot run a criminal background check on somebody unless they're offered the job. California is like that. New York is like that. Texas is now like that. So you can't put on your application, have you been convicted of a felony in the last 5 years? If you're concerned about somebody, then it costs about $40 online to run a criminal background check on somebody. And you can do that. But the other thing is you can't ask whether they're married. You can't ask whether they're a veteran. And you can't ask about any religious orthodoxy they adhere to unless it interferes with the haunt operations. If you get people coming in saying, I can't deal with any kind of scene that has Satan or a devil figure in it, that needs to be disclosed at the outset, and fine, we won't put you into one of those kinds of scenes. That's the only time you can fairly ask about any kind of religious affiliation. And the question is, do you have any religious-based objection to horror or haunted houses in general? People know what horror is. They know what haunted houses are. It's not like you're, asking about physics. So if you ask that question on your application form and they say no, then you put them in a scene and they say, wait a minute, this is very offensive to me because of my religion. You say, well, we asked you that at the beginning, but okay, no problem. We'll move you somewhere where there is no religious overtones whatsoever. And if they say all of this is satanic, okay, goodbye.
Dave was he was adding allergies are medical questions, and ADA says you can't ask until you make the job offer, for
Correct.
example. And then Wendy Wells, can you ask if applicants are over 16, over 18? Is date of birth? She didn't hear the whole answer, but she was asking about age and date of birth, stuff like that.
Yes, if you have an age restriction for your actors, you just make that announcement at the beginning. If you're below the age of 16, we can't employ you. Please leave now. The other thing that you run into with using actors that are under the age of 18 is if your state requires work permits, even for part-time employment. That's something you should talk to a local lawyer about to see how you can use those, or if the state requires it, can you use a kid who's 16, 17, or 18, or 16 or 17 and doesn't have a work permit? Can you still use them? And what is the penalty if you do use them? So age restrictions on actors, on tech, definitely anybody who's working in an area where there's going to be alcohol sold, asking for the date of birth is absolutely no problem whatsoever in the eyes of the law. Because if you put somebody under the age of 21 in most states that have a 21 and up requirement for selling booze, and you put somebody in there even accidentally who's under 21, it doesn't matter. It's what's called a strict liability offense. And that is essentially allowing a minor to transport alcohol. There's fines. Some states have jail time, but that's kind of far-fetched unless you're a repeat offender. It's just best to get their age so you know that they're complying with your age requirements.
Okay. Tammy has got the question, can you get in trouble for false advertising? For example, if you say your haunt is immersive or extreme, but it's just a regular boo haunt. Or do those terms just for insiders and don't mean anything legally, or can you?
That's a good question. Under the law, they call that puffery. You can say things like, we're the best haunt. We're the best haunt in Texas. We're the best does not indicate anything other than subjectivity. Using words like immersive, again, that's a subjective thing. Judges are not going to say, well, this person says it was somewhat immersive, not enough. That is not false advertising. They get laughed out of court. So as long as you're engaging in puffery, you're fine. It's when you start making statements of fact that are verifiably false. Voted number one in the state of North Carolina. By who? Is there any kind of
By my mom.
Right. That's the kind of stuff you want to avoid. I don't even think that would give rise to any liability because, again, the statement has to be such that it would cause the reasonable person to do something they otherwise wouldn't do, i.e. go to your haunt instead of some other one down the street. So if you're not making verifiably false statements of fact, the rest of it is puffery and you're good.
We had the scare factor come through and we were number 3 must see fan voted haunt, which came from the scare factor. So we had the scare factor logo and, so that was kind of like social proof for us to just kind of get started. We first.
And that's the thing is that's verifiable. They can go to that organization and say, is it true they're third by fan voting? Yes, they are. Okay, no problem.
Right. We have Joe was asking about medical consent forms in case actors and staff members would have a medical emergency, call the ambulance. Are those okay?
So well, anybody. Oh, go ahead. Was there more to the question?
Yeah, just can we do that legally? Can we have them fill out their medical information so they could, like, I don't know, allergies or what type?
Well, if it's employees and when I say employees, I mean anybody who works at the haunt, whether they're employed or volunteer. If they have a known allergy, we talked about latex. If somebody has a known allergy that they would necessarily confront on the course where they're going to be, that question should come out. It should come out no later than the first night you're open, saying, hey, does anybody see anything in here that that they're allergic to, because you're not omniscient. You can't tell unless they communicate it to you. Otherwise, you start entering HIPAA, and you don't want to enter HIPAA. That's the federal law of portability of health records, but it also imposes a lot of essentially privileges that people are privileged not to give up information. If you can do that after you offer them employment, you can say, are there any known allergies? And if there are, do you consent to us informing emergency medical personnel of that fact? If not, I strongly recommend that you tell people to get a medic ID, an ID bracelet that will have that information. You're the owner of the haunt. Somebody gets hurt on your property, you're under an obligation, if they don't turn it down, to call medical services to help them. Once you make the call, you're done. You want the relationship to be between the haunt person that's hurt and the EMT who is talking to him. You don't want to get involved in any of that, because it can raise HIPAA violations.
Whatever about like patching your actors up or giving them Tylenol or stuff like that?
I always recommend not to, unless you have a fixed medical on your haunt, like you have an ambulance parked there, or you have some kind of licensed professional. Then it's up to that professional's judgment as to whether to administer any kind of medication or aid, patching them up. Otherwise, it's just best if somebody gets hurt to give them first aid, if you can, like something that would cover a wound, or if it looks like they've got a broken bone, then just send them to the ER. Tell them the best thing for you to do is you're off for tonight, go to the ER and let them check you out.
Very good. Dave was asking, can a haunt penalize an actor by taking away already earned pay as a penalty for being late?
That greatly depends, but I would say the majority of states treat wages the way bankruptcy courts treat wages. When a business declares bankruptcy, if they have employees, the number one obligation they have is to make sure that all their employees were paid for the hours that they worked, or however their wages are calculated. So when you earn a wage, it can't be taken away unless it's a fine, and only a government can impose a fine. So the disciplinary things can be anything that's reasonable short of imposing any kind of fine.
Very good, guys. It's almost 9 o'clock. We're going to try to wrap it up by 9. So if you have any last minute questions, please type those in if you're in Zoom or Facebook, the chat that we have going on Facebook as well.
While we're waiting for any of those final questions, Matt, do you want to let people know where we can find you, we can find your haunts, just a little bit about where they can come see you or contact you if they have any questions?
Sure. The best way to get a hold of me, especially from haunters, and look, I'm on the HOA legal board. If you have questions, shoot them to me. I'll answer them. I don't charge for that. I'm a haunter myself, and I want all haunters to be protected by the law. So the best way to reach me is, again, my email is Matt, M-A-T-T, at the Murphey Lawyers, and Murphy has an E in it. It's M-U-R-P-H-E-Y. Matt at themurphylawyers.com. Feel free to shoot an email, and I usually answer them within 24 hours. We have offices located in Orange County, California, and San Bernardino, California, but our lawyers practice nationwide. If we have cases in other states, we're able to get special appearances in those courts. We don't, however, practice what's called transactional law outside of California and Texas. That is, we don't do mergers and acquisitions. We don't assist businesses in buying or selling their businesses, because that's always peculiar to an individual state law. And our haunt is located in Lake Arrowhead. It's a beautiful resort area. We've got a beautiful lake. In the summer, we're very close to great ski destinations. And and we're open about the halfway point of October till the day before Halloween. And the other way to reach me, and opinions vary on this organization. I do work for it because it does represent haunters. The Haunted Attraction Association, the HAA, I believe it's $50 a year. There are all kinds of benefits. They have videos for teaching things, not just haunt acting, but also how to rig up certain animatronics or building effects out of what you can find in your own workshop. So this, irrespective of whether you're for it or against it, you can reach me through HAA. They will, if you contact them and say, hey, I need to talk to Murphy, the lawyer, they will get it to me and I'll get back to you.
Excellent to hear. Okay, I currently don't see any more questions on the Zoom chat. Brian, do you have anything over on your side from Facebook?
Yeah, Connie was asking, she heard that lawyer conventions are holding seminars at conventions about haunts. Is that true, or?
There's very few conventions for lawyers. And I can tell you, we hate each other as much as the public hates lawyers. So,
no lawyer jokes out there.
Right. So I have not heard of that, if that's the case, but I have spoken at Midsummer Scream and at Trans World. And if that is something people want to hear, shoot the people at Trans World emails and say, hey, we'd like to have some kind of a legal seminar when it's teaching. I'm going to be doing, in connection with HAA, videos. They have an extensive video library, and I'm going to do some answering of questions that regularly come up on video. But if we don't do podcasts like this, the best place to find them are at the industry events. I don't know about lawyer conventions.
And I have a question I was going to ask you earlier, but I forgot. So someone's brand new, starting up, ready to go. What do you recommend them to do legally, like within the first year before they, business LLC, yada, yada? What kind of recommendations?
I don't recommend LLCs because they're generally more expensive. The taxing rate is higher, and the cost to keep them running is higher than a simple C corporation. If they're going to do this and it's going to be off property, off their home site, I strongly recommend that you incorporate, because you want to have that shield to keep you from facing individual liability. You want the corporation to take the fall for anything that goes wrong. So I would incorporate, I would investigate as to whether you need a business license. Most cities or counties require business licenses. And if you're going to do a DBA, as either you as an individual or the corporation, DBA, super frightening haunt, you want to apply through your local newspaper for a fictitious business statement. The law requires usually you run an ad in the legal section of a newspaper, or now the courts are starting to allow online because newspapers are dying out, but it essentially puts the world on notice. This is my DBA name. It belongs to me and I'm going to use it. Nobody else can. It's not the same as a trademark or a copyright registration. It's just to let other businesses know this is who I am. So you can be found through government records. And after that, get a good mentor. I think that's the best thing to do. If you're starting into this, you're an enthusiast, you're somebody who's seen haunts, but never really worked behind them, get a mentor, because you can make some very expensive mistakes when you're first starting out. Hell, even after you first start out, you can make some mistakes, and it's good to have a mentor to help navigate that path.
Very good questions. Thank you guys for your questions. Matt, thank you for your answers. I can send you this video as well. You can use it for your own personal gain. Whatever you want to do with it, I can.
Thank you very much. Thanks for having me on. I really enjoyed it.
Yes.
Oh, you answered some very good questions. And I do know we have some Canadian viewers here. Things are different up here in Canada.
Yes.
So in consult, not insult your lawyer is an important thing to do.
Very much
Okay.
so. For Canada, I'd see a lawyer. You could
Yeah.
insult them too. Most of it had pretty thick skin.
Yeah, let's try not to do that yet. We want them on our sides.
Right.
Very good. Well, thank you guys for a great session. This will be posted at hunterstoolbox.com. We'll put in the feature section for a couple weeks up there if you missed it. It'll be on our Hot Topic podcast as well. So thanks again, Matt. I've learned a lot. So Cammie left a heart in Zoom, and it left some clappy hands. So seemed like you've done a good job tonight. So thanks.
Great. Thanks again, guys.
Thank
You're
you
welcome.
very much.
Signing off. See you next time.
Good night, everyone.
This podcast episode sponsored by Scarlet Badges. Get your Scarlet Badges at scarebadges.com. Also sponsored by Hunter's Toolbox. Take your haunt to the next level at hunterstoolbox.com. Thank you for listening to Haunt Topic Radio. Please leave a comment wherever you found this podcast. Each comment you leave will help spread the word to other haunters around the world. See you next time.